All right. Last time that we were talking, we were just kind of looking at a basic introduction into this whole idea of employment law. Now, I want to go back because one of the things employment law is made up of, we've got constitutional, help me fill in the blank, kind of as a review. We've got constitutional, we've got federal law, statutory law, we've got common law, we've got administrative law, and we have executive law, and I've missed one.
Case law.
Case law, all right? And cases come from where? Courts. Yeah. Some of my questions are not really hard, okay? So just throw out the answer. One of the things that I found over a couple of years of teaching this, and I certainly, again, don't want to insult anybody, don't want to spend a lot of time on stuff you may already know, but I found that a lot of people don't understand the court system or how case works through court. And so I want to spend a little bit of time on this. And by the way, I believe this is going to be either in your administrative materials on Blackboard or in chapter 1 through 4 on Blackboard. I'm pretty confident. Melissa, is it up?
It's there. I tried to print it out, but it didn't print out.
Okay. All right. And I may, it's a little different form, and I may try to get it in there in another format. But this is a flow chart, if you will, of cases. And by the way, we start out with what is called a complaint. What is a complaint? Now, listen, we're not, for those of you who are married, we're not talking about your spouses, okay? What is a complaint? Jackie?
It's someone saying that something wrong has happened.
Yeah. A complaint is nothing other than somebody saying something is wrong and somebody has done something wrong to me. All right? It is, for lack of a better term, a lawsuit. All right? So, give me an example of a complaint. And Jackie's absolutely right. It's somebody has said something's done somebody wrong. Gosh, okay. But give me an example.
I mean, auto accidents.
Okay. I mean, you deal with auto accidents. Yeah. Auto accidents all the time. So if we go, Kyle, I'm just going to pick on you tonight. All right. If we go to the situation where I've allowed my FedEx truck or whatever to run into the back of Kyle's automobile, all right, Kyle is going to be hurt, right? And even if he's not, he's going, right? Okay. And he's going to file a lawsuit that says what? I mean, what's his complaint going to be, and why is he bringing this lawsuit? If he's not hurt, why would he bring a lawsuit? He's not going to. So if he's hurt, yeah, it's his damages, all right? So as a result of me allowing my FedEx truck to run into Kyle, he's been deprived of, he's had to miss school. He's been deprived of the opportunity to be in Law 531, 631, and he has been severely emotionally traumatized as a result of that, okay? So that's what is a complaint. Now, let's bring it back, because eventually we want to get everything into what this class is about. In the employment situation, give me an example of an employment complaint. Jackie?
Termination.
Pardon?
Wrongful termination.
Okay, wrongful termination. Darla, I think you said discrimination. Yeah, same thing. All right, wrongful termination. Somebody has wrongfully terminated me. All right, and we're going to look at some cases next week. Now, the reason, keep in mind as you go through this, there is one of the things that we'll do in this class is what we call briefing cases. All right, a couple of them you will turn in to me. The rest of the time you're on your own, whether you want to do it or not. It's not required except the times I ask you to turn them in to me. But I think going through this process will help you understand how to write your brief and help you understand what the cases is about. So let's go with a wrongful termination. And let's say that Randy Coward or Grant Hayden have wrongfully terminated Jackie, and she files a complaint. Now, by the way, who files the complaint? Who brings the complaint? The plaintiff. All right? The plaintiff brings the complaint. Then you see where that goes out on a motion to dismiss, okay? The motion to dismiss, by the way, can be brought at various stages. We're not going to get into all of this real nitpicky stuff, but this is going to be important because sometimes you'll read cases that say so-and-so brought a motion to dismiss, all right? And you'll want to understand what that is. So who's going to file the motion to dismiss? The defendant, all right? Or in this case, let's just use Randy Coward. He'll love that, I'm sure. And let's say Randy Coward is going to file a motion to dismiss. Now, let me give you what might be an example of why he would file a motion to dismiss. And what is it? Anybody know what a motion to dismiss? Let me just cut to the chase on that. Let me give you a motion to dismiss. Motion to dismiss says that if you take a lawsuit, if you take a complaint and take every word in there as gospel, you still don't have a valid court case. So if we go back to our wrongful termination, if we say that Jackie has brought this complaint saying she has been wrongfully terminated, and Randy says, you look at her complaint, there is no way that it can be valid. Looking just at her complaint and assuming everything Jackie says is true, what might be a reason that somebody would file a motion or a valid reason for a motion to dismiss? Sometimes, by the way, they're filed just as a stall tactic, okay? But what might be a valid reason to file a motion to dismiss? I'll fill you in. Let's say Jackie, this is 2012, right? Let's say Jackie was terminated, Randy terminated Jackie in 2000. Okay? What might be wrong with that?
Statute of limitations.
Yeah, we have what is called a statute of limitations. So if Jackie says in 2012, I was terminated in 2000, Randy can come back and say, you know what? Even if that's true, and yeah, I wrongfully terminated her, I did it, I'm scum, whatever, okay? He can file a motion to dismiss, all right? Maybe it gets ruled on, but that's where the motion to dismiss is. If that is granted, and if a judge says, yeah, you're right, Jackie, you're out of luck, Jackie can then appeal, okay? And that's where you get into the appeal level, all right? And we'll talk briefly because the appeal is where most of your briefs are going to come from. Now, you still see that? Not as good, maybe? All right, we'll scan it down in just a minute. Let's assume the judge says, no, Jackie filed her wrongful termination complaint 3 months after she was terminated, all right? Then who files the answer? Who's going to file an answer? The defendant, okay, or the employer, all right? And from there you have what is called discovery. And your book touches on this a little bit. I'm not going to spend a lot of time on discovery, but interrogatories, which are written questions that you answer under oath, all right? Depositions, which is basically sworn testimony under oath, but before you get to a trial, if you will, all right? Then we have, and I think it's important to understand the difference between a motion to dismiss and a motion for summary judgment. A motion for summary judgment is basically a process that says after we have done all of the discovery and after you have depositions, after you have all of this stuff in place, there are no facts of any importance which a judge could say there is still an issue. Okay? I'm going to give that again. A motion for summary judgment in its legal terminology is that there are no genuine issues of material fact. Okay? For instance, let's say Jackie files her wrongful termination complaint 60 days after she's fired. Okay? And back up, I want to change that just a little bit. Let's say Jackie files a wrongful termination complaint that says, I worked for Randy, okay? Randy wrongfully terminated me. And he wrongfully terminated me 60 days ago. Let's just say that that's the basis of it. If Randy comes back and says, so we've gotten past the statute of limitations. If Randy comes back and says, you know what, Jackie's full of it. She's crazy. She never worked for me. All right? Can he win a motion to dismiss? Jackie, you're, of course, shaking your head no. But why?
Because we said that a motion to dismiss is if you take all of the complaint as true, there's no valid.
Absolutely. If you take Jackie's statement as true, that she worked there, all right, there's no basis, okay? Now, there's no basis for a motion to dismiss. So Randy files his answer. Now what happens is they do discovery, all right? And in that process of discovery, it's just trying to gather information before trial. So let's say that Randy's office is in Springfield, Missouri, but through the process of discovery, we find that Jackie was in Alaska for the last 5 years, all right? And we go and Randy takes depositions or statements and gets them under oath, affidavits if you will, from every person that works there, and they all say, she doesn't work here, she's never worked here, we don't know who she is, all right? At that point, Randy may file a motion for summary judgment. Now, even if Jackie says, no, I did work there, the court's going to say this really isn't a disputed issue of fact because we can prove you were in Alaska. You don't have a W-2. You don't have Social Security. You see what I'm saying? She may say something different, but she might not survive a motion for summary judgment, which basically says, based upon all of the evidence, there is not a material question. Now, I don't care that you really understand that a whole lot as far as knowing all the details about motions for summary judgment. The importance of this is when you read cases in here that talk about motions for summary judgment, you have an understanding of what is going on, okay, and what level it is. So if you read a motion to dismiss, you understand what level that is. If you read a motion for summary judgment or a court case saying the parties come on so-and-so's motion for summary judgment, you understand what they're talking about. So that's why I give you there. Again, if the motion for summary judgment is granted, then Jackie can appeal, all right? And we go from there. If it is not granted, we have a trial. And you know, we won't spend a lot of time on what a trial is. You've seen the trial, okay? And we get into verdicts. Now, I don't care a lot that you know. Again, you don't have to know a great deal of detail about a motion for directed verdict or a motion for judgment as a matter of law, but you get into some situations where you're going to see some court cases that talk about that. All right, let me give you an example of one. We had, gosh, it's been probably 15 years, was trying a case to a jury over two partners that split. They had some kind of computer software program, and I don't know exactly the detail of it. It was medical software. It was supposed to make dealing with medical people easier or whatever. I don't remember all of the details. But we went to a jury trial on it. All right? And I told the court that I really didn't think that the other side had proven their case. All right? So we had a trial. We had a jury of 6 or 7 people. It was in federal court. We had a jury of 6 or 7 people. We tried that case the entire time to the jury. After the jury heard everything, including closing arguments, I filed what is called a motion for directed verdict that said, hey, he's missing one element. The plaintiff is missing one element here. He doesn't prove it. No matter what happens, you have to give me a decision in my favor. And the judge said, you know what? You're right. And it was disappointing for the jury because they had sat there for a week, all right? And then the judge comes out before they get ready to go give their verdict and get into the deliberations, and the judge comes out and says, this case is over. Now, opposing counsel and I, good friends, we went back, we sat down, we talked to the jury, kind of explained what was going on. But that's what a motion for directed verdict is. Judge, before you even give this to the jury, the law is so clear on my side that you've got to give it to me. Okay? Motion for directed verdict comes before the jury gives its verdict. Okay? Same thing as a judgment of matter of law. Now, that doesn't happen very often, by the way. After the trial, you have your verdict. And really the only difference between a motion for a directed verdict and a JNOV, which is a judgment notwithstanding the verdict, is that the judge frequently will say, this jury's been here all week long. I'm going to let the jury deliberate so that they think they're important. And I think that's important for a judge to do, by the way, in most cases. But if it comes back, then I'm going to rule against the jury. And that happens sometimes. Okay? The jury will make a decision and the judge will come back and say, no, we're going to do that. Again, I don't want you to get too caught up in this, but I think it's important to understand as we go through this process of what is, you'll read cases in here and you may come across those terms: motion for directed verdict, motion for summary judgment, motion for new trial, and understand where those come from. Okay. All right. Now, where I do want to spend some time is after a verdict, you may have a judgment. By the way, you may not go through that verdict process if you don't have a jury. Does that make sense? Only juries render verdicts. A judge just renders a judgment. You with me on that? Shake your head yes, nay. Okay. If it's a bench-tried case or a judge-tried case, you're not going to have a verdict because there's no jury. Verdicts are only rendered by juries for the most part. There are a couple of exceptions. You don't need to worry about those. Where most of your cases are going to come from are on the appeal level. All right? For instance, if you read the Target case, the Target was the EEOC case versus Target. Anybody remember that case? Somebody tell me briefly what it was about. Patrick, go ahead.
Mainly it dealt with Target didn't keep all of their records about, I think they had like 600 people that sent in applications and they didn't keep like all of them from a month or something like that. So they didn't have evidence about why they didn't hire some people. Okay.
Yeah, a couple of guys file a charge of discrimination. When we get into the EEOC and discrimination, we'll talk about charges. But in the Target case, a couple of people who had applied for work and didn't get hired complained about it. And they filed what we call charges of discrimination. Now, sometimes the employee is the one, many times, the employee is the one who brings the complaint. And the employee, and they may have to go through a charge process, and we'll talk about that in much more detail, but the employee brings a complaint. Patrick, do you remember who brought the complaint in this one?
It wasn't the employees.
Right.
It was
EEOC.
EEOC.
Yeah, it was the EEOC. And the EEOC said, hey, we want to take this because we think Target's doing something wrong. I mean, that's what happened. So in that case, the complaint was actually filed by the EEOC on behalf of the plaintiff. So you get into that process. Now, the trial court may say one thing or another. Do you remember, and I know I'm picking on you, Patrick, but do you remember what the trial court said? Briefly.
I know that they appealed it afterwards, so they didn't rule in favor to begin with.
Right, yeah. The trial court ruled against, as I recall that case, the trial court ruled against the EEOC. The EEOC appeals it, all right, and the EEOC wins. Now, most of the cases that you're going to be looking at involve appeals, okay? So they've already been tried at a lower level. Now, on an appeal, you have generally more than one judge. All right? Frequently you have 3 judges. Sometimes you can have as many as 7. All right? And I'm laying the foundation here for for your case brief in just a minute, because I think that's going to be important, because most of the time you have an appeal which is in front of 3 or 4 judges. Now, what happens? Let's go back to Jackie and Randy's situation, all right? Jackie gets fired. She claims wrongful termination. Let's say the trial court says, hey, I'm in favor of Randy here. Jackie was not wrongfully terminated. So Jackie appeals, all right? The appellate courts, they don't retry the case, by the way. And I don't know, a lot of people that may or may not know that. The appellate courts get the transcript from the case that was tried below. Okay, they've got a court reporter. They get the transcript. And when they get that, they read it. And they look at it, and they go, yeah, we either agree that Jackie doesn't have a case, or we disagree. All right? And that's what the appellate courts do. And that's where you're going to see most of your cases. Jackie has an automatic right. Most people have an automatic right, one shot at an appeal. Okay? Then you have discretionary levels of appeal. So, for instance, in Missouri, and by the way, I'm not going to spend any time on it tonight, but you may have a flow chart in your Blackboard stuff. You may have not a flow chart, but the different levels of Missouri courts. All right, Jackie would appeal from a circuit court to a court of appeals. Okay, there's another step above the court of appeals, and that would be in Missouri would be what? The Missouri Supreme Court. Okay. Now, Jackie doesn't have an automatic right to go to the Missouri Supreme Court. Okay? She has an automatic right to one appeal, but the Supreme Court can say, no, we're not going to give you. And that's what they call a discretionary appeal. Okay? I don't want to get too bogged down, probably more bogged down than you necessarily need to be. But I want you to understand with regard to appellate cases, okay, they're not retrying the case. They're looking at facts that happen below, and there are generally 3 or 4 or 5 judges. Now, it's going to be generally an odd number that is determining whether the trial court made the right decision. Okay, so that's where you get into on a regular case. Now, just real quickly, and I don't want to spend hardly any time on it, but work comp may be an administrative level type of thing. All right, so in work comp, you have an administrative judge. Then you may go up to an administrative commission and then go to a court. Okay? But so you might skip the discovery process as far as the administrative. You may have discovery, but it's a little bit different. But eventually you're going to get to the appeal process, and that's where most of your cases are going to come from. The reason that I spend this much time, and I know you're going, oh, come on, this is like, I'd rather be at the dentist right now. The reason we spend so much time on that is I want you to understand that framework with regard to your brief writing, okay? Because here are the things that, and again, we'll have this on Blackboard for you. I think I already have it on Blackboard for you, maybe in the case administrative materials. But there is something in there called how to write a brief, how to write a case brief. It's not in the 1 through, it's in the administrative materials, okay? And I just want to go over a couple of things that you're going to need with regard to that information. First of all, you're going to need the name of the case. Okay? If you're writing a brief, it's going to be important that you use the name of the case. That's easy. Then you want facts. All right? And by the way, you don't want to spend, and I give you a couple of examples from a case that you'll read later on, or next week maybe. Missouri does not allow handbooks to constitute a contract. All right, Missouri says a handbook does not constitute a contract. We'll spend more time on that in future sessions. But you just want basic facts of the case. Jackie was fired by Randy. Jackie claims that she had a handbook that prevented her from being fired, and therefore is a wrongful termination. Boom, end of story. You just want enough to clue you in to what's going on. And that's what we call the facts. Then you have what is called an issue. So you got to have a case name. You got to have the basic facts. Then you have an issue. And if we're talking about Jackie and being wrongfully terminated, we're not going to just say, was Jackie wrongfully terminated? The issue is going to be more than that. We're going to say, did Jackie's handbook prevent her from being terminated? Does that make sense? And as you read the I think it's the Johnson case, as you read the McDonnell Douglas case, as you read that case, I think that'll come into play more. But I want to give you a background of it tonight. So the issue is really, what's this case about? If you bear essence again, what is this case about? And then you have a holding, which is the ruling. Okay? And the ruling may simply be a handbook does not create a contract, and therefore there's not a wrongful termination. Okay? Handbook doesn't create a contract, therefore not a wrongful termination. Now, those are easy. Case, facts, issue, holding. Here's where it gets a little more complicated on when you're writing a case brief or when you're reading these cases. All right? If I have 3 judges on the Court of Appeals, and most of these cases will come from the Court of Appeals, will all 3 of these judges always agree? I mean, you can say no. You get 3 lawyers in a room, they're not going to agree. Okay? So, you may have one that disagrees. Okay? You may have one that agrees, but for a different reason. Okay? If you have somebody, the main holding, what we call the majority, okay, that's the majority opinion. If somebody disagrees, and this is going to be a term you need to be familiar with just because you'll see it in your case law, the one who disagrees with what the majority says is what we call a dissenting opinion. A dissenting opinion, D-I-S-S-E-N-T-I-N-G. And basically says, I disagree because of this, all right? You can also have somebody who agrees, but for a different reason, and writes separately. And we would call that a concurring opinion. All right? Let me ask you this, make sure we're all on the same page. Will every opinion by the Court of Appeals, by whichever Court of Appeals we're in, whatever state, whatever level, will every opinion by the Court of Appeals have a dissenting opinion? John? No. Why not? And you're right, but why not?
Because all of the judges could agree.
All of the judges could agree. Sure. And if all of the judges agree, we will not have a dissenting opinion. All right? And the reason I spend so much time on this is I had too many briefs for my that had dissenting opinions when there just weren't any. Okay? So clearly I didn't do an effective job of including what a dissenting opinion was. You may or you may not have a dissenting opinion. Tougher question. The opinion is written by one judge. All right? So you may have 3 judges, you may have 5 judges. The opinion is written by one judge. Will you always have a concurring opinion? Jackie? No. All right. And why not?
Because some might disagree.
Yeah. Well, no, okay. In order to have a majority, Jonathan, you've got to have, if some disagree, you'll have a dissenting. But in order to have a majority, you got to have more than one agree. Okay? But I think you're on the right track. Why may you not have a concurring opinion? What's a concurring opinion again? Jackie?
Where you reach the same, I want to say decision, but that's not technically.
No, that's
correct.
fine. No, that's fine.
When you reach the same decision, but not for the same reason.
Right. Okay? Or you feel really strongly about it that you want to add something else.
Right.
Okay? I'll give you an example in just a second. But if I concur but I don't have anything else to add, there's no reason to write a concurring opinion. Okay? Again, I feel like in past then forgive me if I'm overemphasizing this, but I don't feel in past this. I think I assume too much. Okay? So you may not always have a concurring opinion. All right? You may have those who concur, but they won't write separately. So you'll always have a majority opinion. You may or may not have a written concurring opinion, and you may or may not have a written dissenting opinion. Okay. I represented a student last year, 2 years ago, homecoming, a sophomore who had a legitimate prescription for some kind of narcotic painkiller or whatever, was at a homecoming game. And through the process of being at homecoming game she took one of her pills, she was a cheerleader, took a pill, and some of her friends saw it, and guess what her friends did? Anybody guess? They see her taking a pill. What do? Lisa? Yeah, they ask her for one. And being a sophomore and giving into peer pressure, she does what? She gives it to them, all right? And gets caught and is suspended. And her parents call me to see what I can do. And I thought, man, here we go. We got some parents whose kids out giving drugs and I'm supposed to represent them. This is great. And her parents were very good people. And as I listened to them and put aside my preconceived notions, I realized that what the parents were unhappy about is not the suspension. She got suspended. They appealed. They said, hey, you want to give her a 30-day suspension, that's fine. We'll live with it. 30 days from cheerleading. But in the process, they also decreased her grades by 50%. In other words, they were going to allow her to make up her grades or make up her work that she missed while she was on suspension, 10 days from school, 30 days from activity. Okay? So she's out of school for 10 days, out of cheerleading for 30 days and other sports. And they're going to allow her to make up her homework during that 10 days, but they're going to cut it in half, which means 50% means what, grade-wise? Zero. It's an F, okay? For all practical purposes, it's an F. And she's a pretty good student, okay? She doesn't appeal the 10-day suspension. She doesn't appeal anything but the grades. She lost her A-plus scholarship. Some of you may know what A-plus scholarship is. She lost that. Didn't appeal that. They go to the school district and say, this 50% on the grades, that's just wrong. We're not going to tolerate that, okay? Immediately, and I kid you not, immediately her suspension went from 30 days to 180 school days. And we go, you've got to be kidding. So they come to me and I go, this just is not right. And we appealed it, and we ended up, in fact, filed a lawsuit, went to the board, ended up in court. And we appealed it after, the reason I appealed it, long story, get back, is that we had a case that suggested we were going to be in the right, but the court said, in a concurring opinion, didn't have any different reasons for agreeing that the suspension was wrong. Different court, different facts, okay? But the court in opinion said the legislature needs to adopt a rule that says A, B, C, and D. And that was a case that happened in 80, 85, 86, I don't remember. But we then looked to see if there was a rule, and the court who had written this concurring opinion says you need a law that says A, B, and C. And we pull that and we try to start relying on that. Long story short, just not to leave you hanging with it, is the court said, yeah, you can't, under your particular policy, you can't cut her grades in half. Now, they actually had a board policy that said grades won't be used as punishment, okay? So now what they've done, and I love these people, they were great clients, but now what the district has done is said, okay, we're going to change our policy so that rather than saying you can't use grades as a punishment, we're just going to get rid of that policy. So now we're going to use grades as a punishment. I still think that's wrong, but that's another day for somebody else to argue. But you see the idea of a concurring opinion. Sometimes people can write concurring opinions for political reasons or to suggest something to the legislature. And this particular judge, I think it was Ann Covington out of the Missouri Supreme Court, wrote a concurring opinion, not because she disagreed with the decision of the majority or because she wanted to do it for her own reasons or because she reached another reason. She just said, one of the things you ought to look at, is some law. Okay? So understand, everybody understand concurring opinion, dissenting opinion, say yes or nay or whatever. Okay. The other thing that your briefs will need to contain is rules. What is the rule? And when I talk about the rule, again, you have two examples of these. So we'll give you the framework tonight, and then you can look at it as you get ready to write your brief. The rule is the law, basically. What is the law? All right? The rule is simply what rule of law? If we go back to the handbook, a handbook is not a contract. That is the rule of law. All right? And then you take that rule of law and apply it so that we say, even though Jackie had a handbook is not a contract, and therefore Jackie was not wrongfully terminated. All right? You see what I'm saying? We take the rule and apply that to the particular case. The only other thing I would like in the brief, for the ones you turn in for me, is what's the importance of this decision? Okay? Why do we care about this? All right? What's the significance of this decision? Now, again, I think it's the McDonnell Douglas case. You will have two examples of that case in your administrative or Blackboard stuff, all right? And one of the things that you will find that I say is that they both were good examples. One was extremely, extremely short. And one of the things you'll see that I said was, I think the person who wrote the shorter one actually did the better job, probably spent more time on it because they got their thoughts organized. Why do I care? I want you to understand a brief, but I do it for two reasons. One, so that we can understand this concept of understanding cases, all right? Two, briefs will help you if you'll spend the time to do it. If you're smart enough, you don't have to, great. But if you'll spend the time to do it, the briefs will help you come test time, okay? When you get the opportunity to share with me what knowledge you have gained, all right, the case briefs will help you if you want to do it. I don't require that you do it on every one. I do want a couple just to say, hey, I'm giving you, as an instructor, I'm giving you this tool, and I want to make sure that you understand this tool, but you don't have to do it, okay? Other than the ones that are required. And I think, at least as far as, we'll be asking for a case brief in future classes, okay? We'll talk about that.